Hi everyone, Harry here to talk about the action, or really the inaction, in the two state court prosecutions against Trump. Those would be the ones in New York, where he already was convicted of 34 counts, and what is pending is a motion to dismiss on his part based on immunity. I'll get back to that. And Fulton County, where, recall, there's been this whole dust up and mess involving Fani Willis's affair with the lawyer who was handling the case, and a motion to recuse her whole office for that reason, which the trial court judge denied, but which is now up on appeal. The development today: the Georgia Court of Appeal issued a curt order. It reads in its entirety as follows. The oral argument scheduled to take place on December 4th, 2024 at 10:30 a.m. is hereby canceled until further order of the court. That is Delphic and brief, to say the least, but I think reading between the lines, the two lines, we can make some surmises. So obviously the Court of Appeal is reacting to the Trump election, obviously wants to not go ahead with the appeal if it's going to go away, or if Trump's presidency will somehow preempt it. Now, we've talked about this before. There's no obvious way that it would preempt it, except that any trial, it's true, and of course any sentence would be held in abeyance while he's president. At least that's the likely outcome. Okay, fine. But why then not go ahead with the appeal from the determination by the trial court that Fani Willis doesn't have to recuse her entire office? Why just put it in the ether? And I don't know. People who know the Georgia scene very well suggest that it's a fairly political court, or that just in general politics, red, blue, purple politics, royals, everything. So they've received no motion from Trump, which you might expect. It's happened in New York that, hey, just dismiss the whole thing. I'm president. End of story. There wouldn't be a legal basis for that. But nevertheless, as every prosecutor has said in their motions to the court since the November 5th, these are unprecedented circumstances. So obviously they're contemplating letting the whole thing die on the vine. What would that mean? I think the whole big RICO case, remember from the start, everybody, including I, raised an eyebrow at the breadth of this case and how it encompasses all kinds of conduct, and how incredibly sprawling and time-consuming it would be to try. Maybe they just want to say the whole thing goes away now, but why exactly? There's, the prosecution has a right, an entitlement, a duty, a responsibility to bring cases that they find, and the court can dismiss them, but not because, oh, it's kind of inconvenient now because Trump is president in office. There needs to be something lawful, and there is no legal motion in front of them. Nevertheless, if you're a betting person, the odds, and I've been saying for some time that the odds that somehow, in some way, this case will not be exhumed and we won't see it go forward have been substantial. And now you got to think there more, that the whole thing might just not pan out. A little aside here, that has to be quite a matter of chagrin for the defendants who already pleaded out in the case. They're probably kicking themselves. But remember, this is a 19 defendant case originally, and in addition to Trump, it's the whole cast of characters, the whole stinky crew of Mark Meadows, Rudy Giuliani, and different lawyers. So there is a lot at stake here besides the criminal liability of Donald Trump. Now, there's a lot of evidence that necessarily would come forward that Trump or others might try to say, oh, you can't try to do that because of immunity. There's a lot of arguments that Trump could make to say just vaporize this case. But A, it's not clear really what they are. It's a state court case and plenty of defendants other than him. And B, there is no such argument before them. So this is a Delphic order from the Court of Appeal that certainly, I think, reflects a lot of action and turmoil behind the scenes, and certainly makes it seem more likely rather than less that the case is not going to happen, and certainly not going to happen in the near future. But why not? How not? In response to what is just a mystery. This is just not a normal kind of order in a case like this. Not just the hereby canceled, they would say postponed. Canceled implies, done, ain't coming back. And until further order of the court is, don't call us, we'll call you. So that's funky, to say the least. And it overall has to be mildly good news for Trump and his co-defendants, who are hoping that somehow, because of the election, they get a free ride, as it seems that Trump may well. Okay, and we've had sort of similar, not quite the same, but a similar kind of inaction in the New York case in front of Judge Merchan. Today was supposed to be a hearing where the judge would talk about Trump's motion to dismiss. He's made a motion that we've talked about before, saying you used some evidence that the Supreme Court says you shouldn't have in their immunity opinion. The argument is that the conversation with Hope Hicks after he was president, when the Stormy Daniels story came to light in the Wall Street Journal, was part of his official capacity. And moreover, that the error really affected things. The argument on the other side is probably that it isn't, and most importantly, that it's harmless error within the meaning of the Constitution and the rules of criminal procedure, meaning you don't get a new trial anyway. That's what's in front of them, but so far the sentencing has still been set for a week from today, the 25th, and that was a whole separate motion. Today, however, that looks to be no longer the case, because we have a letter. First, there was a report. It's a little bit equivocal that Merchan was taking things off calendar. I don't know if that's gone sort of ambivalent or conflicting reports, but it doesn't really matter, because what happened thereafter and within the last hour is a letter from the DA's office to Justice Merchan saying, as a result of the election, defendant asked the district attorney to dismiss this prosecution. No way, we are not doing that. And we believe that you, Justice Merchan, should set a motion schedule for his forthcoming motion to dismiss, which we are going to oppose. The motion to, dismiss the whole case because of the immunity opinion and because of his election as president. So this is different from new trial. It's just scuttle the whole thing. We're going to oppose it, and we're going to take the position that you should proceed with sentencing, I think, even if he's president. No current law establishes that a temporary immunity from prosecution requires dismissal of a post-trial criminal proceeding. They're saying it's one thing to indict a sitting president. The OLC memo suggests you shouldn't in the federal system. Would that apply in the state system? Maybe. Some of the same considerations. But now everything's all said and done except for the sentencing itself. That's a little appearance. And whether or not Trump serves it is one thing, but that's different from whether Merchan announces it. So they're taking the position that you should go forward, you should sentence him. However, we do not oppose, and given what the court may have done this morning and just the way these things go, a stay of further proceedings until you first dispose of that. We recommend that you make him file his motion on December 9th, and we'll proceed accordingly. It seems to me that would likely translate to a calendar that goes after the decision on whether to dismiss would go after the inauguration. He'd already be president, and now we have this separate motion that surely Trump will oppose, and that's not settled, where he'll say, but we can still go ahead just with this post-trial proceeding, and you should. So we'll see what happens there. The immediate headline is no sentencing next week, and Trump's going to be better armed to say no sentencing at all. Not the same as dismiss everything, but no sentencing at all, because he'll be president, and the counter argument that will be served up to Merchant in the first instance, but could then go all the way up the New York system and over to the U.S. Supreme Court on a question of federal law, is whether you can have a simple post-trial proceeding like a sentencing, even for a sitting president. So that's a fight that's brewing and will be coming soon. The immediate point for today is no sentencing. Instead, we'll await Trump's motion to dismiss the whole kit and caboodle. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.